Welcome to the 2020 Virtual Spring Meeting, brought to you as a special edition of Our Curious Amalgam, the American Bar Association Antitrust Law Section's podcast. Virtual Springs Eternal, Friday, April 17th through Friday, May 1st, as we bring to you some of the top programs from the now canceled in-person spring meeting, as well as new hot off the press programs discussing the most compelling issues of the day. Be well and enjoy the show.
Hello and welcome to the Virtual Spring Meeting. My name is John Roberti. Today we're delighted to present yet another great panel. No-poach, Assessing Risk in Uncertain Seas. And the panel is presented by the Cartel and Criminal Practice and Trial Practice Committees. And with me to provide some context are Beatrice Mejia and Leslie Kostashak, two of the vice chairs of the Cartel and Criminal Practice Committee. Beatrice is a partner at Cooley LLP. Hi, Beatrice.
Hi, John.
And Leslie is a partner at Hunton Andrews Kurth. Hi, Leslie.
Hey there, John.
Beatrice, let's start with you. What's today's program about?
Thank you, John. Today's program is about the no-poach landscape. In the fall of 2016, DOJ and FTC issued guidelines indicating for the first time that no-poach agreements or other agreements impacting the labor market might be treated as criminal as opposed to civil antitrust violations. Our panelists today will address some of the issues in prosecuting those types of agreements in the civil and criminal context.
Great. Leslie, Beatrice, why is this all important?
This is all important because since issuing those guidelines, DOJ and FTC have indicated numerous times that they have many investigations ongoing and have promised indictments and prosecutions. And most recently, on April 13th, DOJ and FTC issued a joint announcement indicating that they are on alert of employers who enter into agreements that impact labor markets in the context of the pandemic. So it's clear that DOJ and FTC remain focused on these types of potentially anti-competitive agreements.
Interesting. Yeah, it's an issue we've been watching for some time, but again, seems to continually get refreshed.
That's right.
What are we going to get out of today's panel?
So I think our audience is going to come away, one, more educated about some of the challenges that enforcers and practitioners are going to face in prosecuting and defending cases involving no-poach agreements or other anti-competitive agreements impacting the labor market. There are going to be issues around how to define the relevant market, how to assess impact on that market, some of the core questions that are part of an antitrust case are going to pose some challenges given the uncertain landscape.
Beatrice, thank you. Beatrice and Leslie, both of you, will you stick around? Let's listen to the panel together and then maybe come back together and we can talk about some takeaways. Is that okay?
Sounds good.
All right, well then let's send it over to the moderator of today's panel, Adam HEMLOCK. Adam, it's all yours.
John, thank you very much and appreciate the introduction. So this is our panel, No-poach, Assessing Risk in Uncertain Seas, and what we're going to be talking about for the next hour or so is the state of play in no-poach litigation and enforcement. We have a great panel with a diverse set of voices to talk about a subject that's really on the minds of a lot of antitrust practitioners today. So first, let me introduce our esteemed panel. First, we've got Dean Harvey. Dean is a partner at Lieff, Cabraser, where he practices representing workers, consumers, small businesses, and antitrust and IP cases. He previously worked for the Antitrust Division at the Department of Justice, and he was a law clerk to the Honorable James Selna of the United States District Court for the Central District, California. He's also co-chair of the Antitrust Section's Competition Torts Committee. Welcome, Dean. We've also got Mark Hamer. He's a partner at Baker McKenzie, and he is an antitrust litigator, both public and private. He's global chair of the firm's antitrust and competition practice. Before joining Baker, he was a federal prosecutor in the antitrust division at the DOJ. He was involved in some of the DOJ's highest profile antitrust trials. We also have with us Susan Musser. She's a senior associate at Hogan Lovells in their global regulatory group, assisting clients with cartel-related issues. Prior to joining Hogan, she clerked for Judge Wolf at the Missouri Supreme Court, and following that, she was with the Antitrust Division at the DOJ through the Honors Program as a trial attorney. And finally, we're privileged to have Rahul Rao with us. He's currently an Assistant Attorney General for the state of Washington in the Antitrust Division. He began his legal career as a judicial clerk for the Chief Judge of the D.C. Court of Appeals, Eric Washington, and subsequently worked in the trial department at McDermott, Will & Emery, and later joined the litigation practice at Morgan, Lewis & Bockius, where he practiced white-collar and securities defense. So welcome to all of you, and thanks very much for joining us today. Before we dive into hearing some of the great thoughts we have from our panelists, I'm going to briefly outline a little bit of the history of the law and the policies and enforcement on no-poach over the last 10 years or so. I would say that no-poach really came into prominence in the second half of the first decade, the first in 2000s, when the DOJ commenced an investigation into alleged no-poach agreements between various Silicon Valley firms. That eventually led to several settlements with the DOJ. 3 of them were entered into final judgments with famous companies such as Adobe, Apple, Google, Intel, Lucasfilm, eBay, etc. Notably, these were civil investigations. They were not criminal, and the settlements were civil in nature as well. As is often the case when the DOJ investigates and there are dispositions, the civil litigations follow. There were significant class actions filed on behalf of various types of employees that were apparently the subject of the DOJ investigation, and those cases settled for substantial sums. One particularly notable settlement by Adobe, Apple, Google, and Intel was for $415 million in September 2015. So from the civil perspective, the concept of no-poach has certainly been prominent and one that practitioners and advisors have been mindful of. The next step, and really what has caused a lot of people to be focused on no-poach, is the DOJ FTC antitrust guidance for human resource professionals that was released in October 2016. And what's critical about that document and the policy that the agencies now have is that with respect to naked no-poach agreements or understandings, the DOJ intends to prosecute those criminally. And that is something that I think had been considered a possibility perhaps in the past, but really simply put was not on everybody's radar. The DOJ has since indicated that there are many no-poach investigations underway. At various times, the DOJ has indicated that either pleas or indictments are imminent. Frankly, there have not been the number of pleas and indictments that the DOJ kind of got us all excited to see, but that's not to say that they're not investigating, and I think the word around the campfire is that there are investigations, but they just haven't gotten to the level of a criminal disposition quite yet. But in the meantime, the fact of the DOJ's announcement and their intent to focus on no-poach as an area of criminal prosecution does have a lot of corporations and practitioners very focused on this now, and that leads to our esteemed panel, which is going to talk a little bit about how antitrust law applies in this area and what we might expect going forward. With all of that, I'm going to turn it over first to Dean Harvey, who's going to talk a little bit about the economics of labor markets, market definition issues, and how you fit no-poach and similar related agreements into the typical antitrust analysis and paradigm. So Dean, why don't you take it from there?
Thank you, Adam. It's a pleasure to be here. There are a number of significant differences in how one, I think, should think about a labor market as opposed to what antitrust practitioners are more accustomed to, which is a product market of some kind. The first thing to think about, I think, is perhaps a way to talk about these differences is to compare, say, a market for bars of soap versus any kind of labor market you could imagine. And one important difference that jumps out is that the transaction costs are very different. So if you need a bar of soap, you walk into a store, you go to the soap aisle, or the aisle where there are, perhaps 20 brands of soap. They sit on a shelf, there are prices next to it, you decide what kind of soap you want, you pick it up, you buy it, and that's that. Very simple, essentially no transaction costs, perfect information about price, and you have a very good idea about quality. We're used to thinking about markets like that. Now, how does that compare to a labor market? Well, in order for a labor market transaction to take place, someone needs to be hired, and then that person needs to be paid. So what goes into that? On the front end, you have the employee who is searching for a job, perhaps by word of mouth, by family connections, by doing online searches, et cetera, et cetera. In many cases, spends most of their lives angling for a particular job. It's a huge part of someone's life in terms of figuring out what kind of job you're going to do and who you're going to work for. And then on the other side, you have the employer who is looking for a worker and is well aware of the costs of hiring a bad worker. You can't hire and fire on a dime. There are a lot of regulations involved and a lot of sink costs in terms of when you first hire someone. Very often there are training costs and other things, and you may operate essentially at a loss for that person until they're trained up to a point where the revenue to the employer, the productivity that the employer is able to enjoy is more than the pay plus the training costs, et cetera, for the employee. A very complicated transaction. Once that transaction takes place, it again is very different than when you're buying something like a bar of soap. When you buy a bar of soap, that's it. You use it, you need another bar of soap, you go into the store, the price may be different. One store may charge very different prices. For a worker, ideally, and in the vast majority of cases, jobs last more than a day. They last years, in some cases decades. It's a relationship that social psychologists and labor economists akin to a family relationship. And in fact, surveys that social scientists have used show that with the death of a family member, marriage and divorce, and the birth or death of a child, getting hired or fired is right up there. It's one of the major life events for a person. And that pay for that person is also set in a very different way. So, for example, the prices for individual transactions can change. They can go up, they can go down. There could be, a sale on Tuesday for soap that then on Wednesday goes away. When you start a job, when anyone starts a job, it starts at a rate of pay that is very sticky. It will persist over time and typically only goes up. Very rarely, unless you're talking about variable compensation like bonuses or commissions, rarely does someone's base pay go down over time. And that will only occur in unusual circumstances where the company is in dire straits, on the verge of bankruptcy or something like that. But most of the time, pay is akin to a one-way ratchet. It only goes up, which again is very different than in the product market. Another key difference is when you step back from an individual person and look at groups of people at an employer, pay works very differently than prices of products. So again, going back to the soap example, look at a soap manufacturer, say Procter & Gamble. I'm assuming they make bars of soap. I don't know that to be true, but I just suppose they do. And they also make all kinds of other products. The price of a bar of soap doesn't necessarily impact the price of tabletop cleaner or sanitary wipes. They are, each of them properly conceived as separate product markets, you ask the usual antitrust questions about substitutes to ask whether they belong in the same antitrust market. In the employment setting, those questions don't really make sense and they don't really apply. So for example, in the no-poach space, employers in the cases that have been litigated are alleged to have agreed not to compete with each other for employees, full stop. Not particular titles, not particular skill sets, but we're not going to compete for employees. The way those civil cases, civil private cases have proceeded on a class basis is that the classes that have been alleged and certified include a wide variety of skills that are in no way substitutes for each other. In the same class, for example, in the high-tech case, there you had 7 defendants in the same class of skilled tech and creative workers. You had everyone from a storyboard artist at Pixar working on movies to a hardware engineer at Intel working on CPUs, all part of the same class. And the way to think about impact to those people in a common way is, I think, out of the comfort zone for a lot of antitrust lawyers and antitrust economists. What has been at issue in these cases is the firm-wide pay structure that the plaintiffs assert exists at a certain company that would commonly suppress the pay of everyone at that company. So for example, at a company, usually pay changes are made in a systematic way, usually on an annual basis. There typically is a company-wide percentage merit increase that can deviate based on performance on an individual level, but will very often have some kind of base percentage increase that at the very least will keep up with inflation. And so the impact across different types of employees, across different kinds of individual transactions is also very different. And I'd like to shift now to just the implications of these economic differences to the antitrust analysis. And again, I want to compare what we do, what we're used to lawyers who have been dealing with labor markets for a long time, employment lawyers. And think about your typical employment case. Let's say a sex discrimination case. Company X is alleged to systematically discriminate against women. In no discrimination case ever litigated is a plaintiff required to define and prove a relevant market for the relevant skill sets of women at that company. They don't have to prove that that one employer that discriminates against women has a large market share of all employees in that geographic area for a particular skill set. It just never comes up. It's never occurred to any court in any employment case ever litigated. And I've made this point in several fora, and I've asked if anyone in the audience, which typically includes a lot of employment lawyers, know of a single example of this happening, and I've yet to hear of a single example. If you know of one, please let me know. And so I think the question is, why is that? Why in employment cases are what we typically focus on, antitrust markets, why has that never come up? And the reason is for, I think, all of the differences I described in terms of the economics. A discriminatory practice at one employer can suppress pay of women because of all the frictions that exist. And so these are the issues that come up in these cases. Of course, this is a matter of significant debate and argument in these cases where defendants will, as much as they can, try to fit their labor market into what looks more like a product market. And so they will often urge courts to look at it in that way, where, for example, in the high-tech case, the market for tech workers across the country. If you looked at that in any kind of traditional antitrust sense, you would say that these 7 defendants had a fraction of 1% of the relevant nationwide market for essentially every creative tech worker in the country. That sounds like, it would get to a place perhaps where a court would doubt that there could be any kind of impact to the alleged misconduct. And so those are the outlines of kind of I think the most fundamental important economic arguments and how they relate to the legal implications for antitrust cases. The last item I wanted to mention, I just want to pick up on what the regulatory agencies and enforcement agencies are doing in this area. After the guidance for HR professionals came out from the DOJ, the U.S. Department of Justice held a workshop in the fall on antitrust and labor issues. And I think the DOJ is working through a lot of these issues in terms of are there important differences between labor markets and antitrust markets, and what impacts should those differences have, if any, on the way the DOJ enforces the antitrust laws. The FTC also had a workshop and solicited comments on a particular area here, which is non-compete agreements. That is not no-poach agreements between employers, but agreements between employers and individual employees that after termination of employment, the employee will not work for a competing company within a geographic area for some set amount of time. Those kinds of non-compete agreements have received increased scrutiny of late, and the FTC and several members of Congress are considering steps to regulate or perhaps even prohibit those kinds of agreements. And the FTC is currently soliciting and entertaining comments on that. And I know the American Bar Association, the antitrust section in particular, has a comment that they are working on that will be submitted to the FTC shortly.
That's great. Thank you so much, Dean. One quick follow-up question. I mean, one of the interesting issues I think of in this space in terms of relevant market is with respect to many jobs, you can imagine that people who take those jobs are willing to do a variety of other things, right? So take manual labor. There may be someone who works in a fulfillment center at Amazon, putting items into boxes to be shipped out to customers, but that person may be willing to take a variety of other jobs at many different local businesses, doing a lot of different manual labor, in other words, not requiring high skills. And the question is, how do you fit that into the relevant market paradigm? Because, you'd say, well, Amazon fulfillment centers, are there other fulfillment centers or other warehousers in the area, warehouse distribution centers, et cetera? But how do you shape what that worker is going to be willing to do, and what other jobs he or she might find to be acceptable? That's something that's always struck me as kind of an interesting question.
Yeah, thank you. Up until the rail no-poach case, which recently settled and where I represent plaintiffs, and in the fast food no-poach cases, all the other cases that have been litigated to judgment or to a final settlement involve highly skilled workers. So then your question is, well, what about lower skilled workers? And that has certainly come up in the franchise context, where you're talking about, and there are many cases across the country right now where the alleged class includes entry-level workers at a McDonald's franchise, for example. The rail case, which was recently settled, involved workers that had a certain set of skills, but perhaps not to the extent of, say, the doctors in the Duke case or the software engineers in the high-tech employees case. And there, what I would say is, I think there are two points in time to think about this. One is at the moment at which they are hired, to what extent is their pay competitive? And then what happens after that over time? So at the outset, I think whether you're skilled or not skilled, when you're first hired, you have to convince that person to come work for you and to accept your offer of employment over other offers. And that, and as many studies have shown, when you change jobs, that's when competitive forces are working at their best. And you're able to get or come as close as you can to obtaining the value of your labor in terms of your own compensation. After that, though, that's a different story, where many workers, once they have a job, are very reluctant to quit that job and go work somewhere else for just a slight improvement in pay. There needs to be some pretty significant event or disparity in pay to get that person to leave. And so then over time, what is happening to that worker, even a low-skilled worker? That worker is learning how to do their job better over time. They're creating more value for their employer, and their pay may be static, may not be going up. So over time, that employer may be able to get more and more of that increased productivity. And I think many labor economists have pointed this out, that it's one of the great mysteries of the last few decades, that as productivity has gone up, pay of entry-level, low-skilled workers has not gone up. Why is that? And it's because they're exercising market power. So the question is how. In the context of a no-poach agreement, you're eliminating a source of competition that plaintiffs allege impact pay throughout that company. And so you could imagine that the impact may be different in terms of degree as between certain subsets of workers, but certainly what plaintiffs allege, and defendants of course disagree with this, but in these cases, plaintiffs allege that in the but-for world, a world without the restraint on competition, that even low-skilled workers would be paid a little bit more. And then the extent of that, whether that's the case, of course, is a battle of the experts.
That's great. Thank you. Let's turn it over to Mark. And Mark, I think you were going to talk a little bit about enforcement in the United States versus other jurisdictions.
Sure. Thanks, Adam. And actually, before we leave Dean's topic, I just wanted to add a couple of thoughts, I guess, from a defense perspective on the issues about labor markets. I think Dean did a very nice job of identifying the reasons that labor markets can be very different. And because of that, assessing harm from agreements that affect those markets can be very complex and nuanced, which kind of leads into arguments that the rule of reason should apply rather than per se for agreements that affect that market. And that's kind of where many of these arguments in the cases have come from, the idea that because labor markets are different in many of the ways that Dean has highlighted, courts should be cautious before concluding that an agreement to not solicit or hire employees across competitors harms competition before making a full market assessment of the impact on those labor markets. And as you highlighted, there is a growing interest abroad. It's not just the U.S. now that is focused on no-poach agreements. As you highlighted nicely at the beginning, it's been around for a decade or more. And as often is the case, a lot of other enforcers have shown high interest in no-poach agreements and have started investigating them. So for companies that are assessing no-poach risk, it's now not just a U.S. problem, it's a global problem. A couple of them of note to highlight. First, there are two countries long before the 2016 guidelines that had shown interest in no-poach agreements. That's Spain and Turkey. Back in 2010, about the time of the high-tech cases in the U.S., in Spain, there was a freight forwarding cartel that resulted in a pretty significant fine against 8 companies that had a series of conduct issues, but one of those was a no hire among those cartel participants without approval of the others. And similarly in Turkey, again, before the 2016 DOJ FTC guidelines back in 2005, there was an investigation of TV producers into both wage fixing and no-poach agreements among them. And similarly in 2011, Turkey was looking into the same type of conduct among private schools. After the 2016 guidelines came out in October 2016, there were a series of pretty high-profile announcements or investigations from some major enforcers. France in 2017 investigated a cartel in the PVC linoleum floor coverings markets that resulted in a significant fine. And among the cartel activities included non-solicit agreements and agreements among exchanging salary information across the cartel members. The Netherlands in 2017 also took a look at no-poach issues among hospitals and did apply more of a rule of reason approach as opposed to a by-object approach to the no-poach agreements, but was very interested in their impact on competition. In the United Kingdom, CMA has had a couple of announcements. One in 2018, they identified 5 industries of high risk for cartel activity. Recruitment was one of those. And then more concretely, in 2019, they had an investigation in the rolled lead market for suppliers in that market. And among price fixing activity, there was also no-poach activity that got CMA's interest. In Asia, there have been a couple of headlines of enforcer interest, but most notably Hong Kong and Japan. So in Hong Kong, of course, the Brent Snyder from the DOJ Antitrust Division went to the Hong Kong Competition Authority, and his arrival coincided with no-poach announcements from Hong Kong, making guidance for participants in Hong Kong about the importance of avoiding non-solicit agreements. The JFTC in Japan had a study group on human resources and competition policy in 2018 that highlighted the risk both of wage fixing agreements, but also no-poach agreements, and has more recently investigated the track and field industry for no-poach conduct. And I won't go into detail, but several other countries, including Croatia, Denmark, Egypt, Finland, Italy, Portugal, have all had some type of investigation that touched on no-poach or non-solicit issues. And then even in the Americas, more recently, Brazil. To answer your question, just a U.S. issue, it's a global issue, and it's creating headaches for multinationals with global workforces to be sure that whatever compliance programs they have are accounting for the potential antitrust enforcement risk for no-poach agreements, not just in the jurisdictions that have been acted, but potentially in others that might follow the lead of the ones we mentioned.
So, Mark, thank you for that. It's very interesting. Just one quick follow-up. I've always found it a bit odd that, on the one hand, I think historically the U.S. has been perceived as being more adhering to economic principles in its enforcement of the antitrust laws vis-a-vis many other jurisdictions where there may be more policy considerations outside of economics that drive enforcement in other places. And yet, oddly enough, you take employment and labor and people's livelihoods as a quote market that you would think kind of would be an area that would be of greatest significance from a political perspective, and yet it was the U.S. that kind of introduced antitrust to that, or at least made it popular, if that's the right term, vis-a-vis a lot of other jurisdictions. Any thoughts to that?
Yeah, that's an interesting observation. I mean, so many of these things are happenstance based on the facts that are presented, right? So the high-tech facts came upon the DOJ's desk, and that started the whole trend. So I think, that's the only reason I would think that U.S. was a lead on it. But I do think you're onto something, because a lot of the employment is so important in general in every country, and particularly when you have a dynamic where there might be a non-local employer, global employer, with an agreement that might impact a workforce could be a very small country. That local enforcer might get very, very interested in making no-poach antitrust investigation a priority for it.
Yeah. All right, great. Well, thank you. Let's turn it over to Susan now. And Susan, we're going to ask you to focus a little bit on the DOJ criminal enforcement aspect of all this, and maybe talk a little bit about that.
Sure. Thanks so much. So, as Adam mentioned, kind of when he started this whole thing off, we've been hearing a little bit that, winter is coming, but, we haven't quite seen the Night King yet. So, so far there have been no criminal indictments that we've seen. However, in various division speeches, Macon and others at the Department of Justice has certainly indicated that these are on the horizon. I think it's going to be really interesting to see what types of cases they bring and in what markets and how these play out. I think there are two particular aspects of a criminal no-poach case that are worth kind of discussing, and it's really the beginning and end, right? So, as Rahul will mention, there's a lot of discourse about how to treat no-poach cases, right? Some folks have been leaning more heavily towards the rule of reason, maybe not quite incidentally, the defense bar, and other folks have been arguing for per se treatment. And how courts have decided whether and how to treat these cases has really depended by court and by type of agreement alleged. And in this 2016 guidance, what the division said is that it was going to treat naked no-poach agreements as criminal. And naked quite simply means it's not ancillary to any per se or to any pro-competitive agreement. So think about, a joint venture that has some sort of non-solicitation or no-poach agreement as part of that joint venture. Now, I like to think of these cases as a bit of a spectrum, right? There are some that are very clearly completely naked. The agreements have no close. And there are others that, there's clearly some sort of other agreement that it's intertwined. But then there's this kind of body of agreement in the middle that's just a little difficult. And I think that difficulty, that vagueness, is really hard to deal with in a criminal context. And the reason being is that the prosecutor decides whether or not to treat a case as per se versus rule of reason. And now, in the private context, of course, the private plaintiff brings the complaint that they're going to bring, but there's, in the criminal context, very little opportunity once a grand jury returns that indictment to push back on that. And so I just wanted to unpack that a little bit. So, it's kind of an anomaly of our system that before trial, the criminal defendant actually has very few rights as compared to a civil defendant. So take the grand jury itself. There's no due process right to have exculpatory evidence presented in the grand jury. There's also no right to have a witness in the grand jury. Instead, the prosecutor really gets to use that as a vehicle of its charging decision. So it decides what facts to present, how to present those facts, and then what indictment to return. And so once the grand jury turns the indictment, it's really in the form that the prosecutor has decided. And having been on that side, I really don't believe that there's any nefarious perspective in that, but there isn't a lot of opportunity for engagement during that indictment process. In fact, there's really no formal opportunity, just informal negotiation. So once that indictment's returned, you also have very few opportunities, particularly when you want to compare it to a civil case, to push back on that and just tell the court that, DOJ got it wrong here. This really isn't a per se case. This is a rule of reason case. Because the way that the criminal procedure works, of course, is that, the only requirement of an indictment is that it gives the defendant notice of what they've been charged on. And quite simply, most courts say that that's just the elements of the charge. And so trying to get an indictment dismissed in the criminal context is really just much harder. So practically, you have to rely on motions in limine and jury instructions in order to try and get evidence of a rule of reason, or evidence kind of about the effect pro-competitive justifications of a restraint before a jury. So I think that just makes these cases a little bit harder to try. So that's kind of the beginning of the case. I think that these cases also present some practical challenges at the very end. So criminal antitrust lawyers aren't technically we don't tend to deal with harm and effect as much as our counterparts on the civil side. Normally, we lean pretty heavily into per se. We show there's an agreement, and that's the end all be all. However, I think that these cases, we're going to see how we're going to get into more civil style mechanics of how they operate. particularly when looking at how to apply the sentencing guidelines in these contexts. So the way that the guidelines work, as I'm sure everyone's familiar with, is that the guidelines say that there's a 20% kind of heuristic that's used. And this 20% it measures is multiplied against the volume of commerce to get your base fine. Back when the guidelines were originally written, this 20% rule was based on these various economic studies that had said that 10% of a price fixing conspiracy and a bid rigging conspiracy is just a good general proximity, right? And this general proximity multiplied by 2 allows for a penalty, and this is a good placeholder, so that in a criminal context, we don't need to get into damages calculation. We don't need to bring in economic experts and do the whole civil style damages analysis. Instead, we can take the 20%, multiply it by the affected commerce, and then once we have that base fine, multiply that by the minimum and maximum multiplier. And these minimum and maximum multipliers, of course, are determined by various inputs that are designed to enhance the fine, the more culpable the organization, and reduce the fine, the less culpable organization. But I guess the question is, in the no-poach context, does this make sense, right? Because under Booker, these guidelines aren't mandatory, but are, of course, discretionary. And accordingly, there is opportunity for parties to advocate either before the DOJ or court that they shouldn't be bound by these guidelines. And then that 20% heuristic, that estimate, just doesn't make sense here. And why is it? Dean had started off the conversation by just talking a little bit about labor markets and how they differ from what we consider as a traditional product market. And those differences may matter. I think that depending if you look at a case where there's a two companies that have only a small two companies that are a small percentage of the employers of finance officials across the entire nation, there's at least an argument, right, that those two companies that maybe had an agreement affecting finance officials, that agreement is a little different than what we would see in a product market. And maybe that difference, the way that this conspiracy played out, means that this 20% guideline, this 20% default, just doesn't make sense here. That maybe it's a little bit more, or maybe it's a little bit less, depending on how the agreement actually affected the market at issue. I think that this is a very conspiracy-specific inquiry. It depends a lot on kind of what the alleged scope of the conspiracy is and how the labor markets are alleged. But I think the big point is that I do think there's room to argue that these no-poach cases should be treated a little bit differently, right? That we shouldn't just assume that a mechanical application of the sentencing guidelines makes sense here. And so could be a little bit more room as an advocate to argue before the court or DOJ that we really do need to bring in our economic experts. We really do need to dig in to a more of a traditional civil modeling exercise to see what the market is at issue and what the harm is, to determine whether or not the sentencing guidelines make sense. And this, of course, not only applies when we're thinking about how to assess harm, kind of the whole process of that, but also even if we do apply the 20% guidance, how do we apply it? Everything from what is affected commerce. Dean mentioned in his opening remarks, right, that the Silicon Valley cases, they kind of assumed that the way that they looked at the class was that it affected an array of positions. So does that mean, what is that array? What is the scope of that commerce to apply that 20% calculation to? That's obviously one end of the spectrum if you kind of assume a market-wide effect. But on the other end of the spectrum is looking at whether it's all open positions, or maybe even more narrowly, all positions that were kind of subject to the agreement, maybe that they had an opportunity to recruit for, right? Those are all questions I think that will need to be answered and negotiated as people are working through how to apply the guidelines in this pretty unique this unique type of case. And then finally, of course, I think it's going to, also be a challenge to think about what is the commerce. So even when you know the scope of the agreement and the scope of the positions, how do you measure how much has been affected? Is it their salary? Is there a salary plus benefits? How do you measure maternity benefits? How do you measure childcare? How do you measure flex scheduling? These are all questions that I think are going to have to be thought through when folks are considering how to apply the guidelines in a sentencing context.
That's great, Susan. Thank you so much. One question in my mind that pops up, you talked about how there may be a little bit more wiggle room than in a typical product market when you're going to be sitting down across from the DOJ to negotiate a plea in this space. And part of that wiggle room arises from the novelty of applying criminal antitrust enforcement in this market. One question, do you think that the DOJ would factor in whether an agreement that's the subject of negotiations was a straight out no poach? In other words, straightforward, we're not hiring your people, you're not hiring ours, versus something more subtle like a non-solicit, like, well, we won't actively solicit your employees, but if they call us, then we're allowed to hire them. How much play do you think that would get with the DOJ in terms of negotiating, say, within a fine range?
I think the answer is I don't know. I think it's certainly something that it should be negotiated and should be a topic of conversation. I think a lot of it depends on, based on my experience with the division, once a division has a certain way they treat a type of case, it's harder to get them to shift their position. So I think that if you're first in line and you can, articulate why your clients, why the scope of the conspiracy is different, and at least once you have that guidelines range, it should be, bumped down. I think that's an argument worth making, and I have no reason to think that they wouldn't be amenable to that. Again, I think that I would encourage. I think we need to be thinking about how we make that argument. Right? Let's get in the economist early and talk about why it makes a difference. Again, having worked on both the civil and criminal side of the antitrust division, the criminal folks just aren't used to leaning as heavily on the economist as early. So I think it's going to be something that folks who are advocating on behalf of clients should introduce and say, hey, let me walk you through it. Let me explain this. And I have no reason to think that they wouldn't be open to, whatever you wanted to argue.
Okay, that's very helpful. Thank you. All right, finally, we're going to turn it over to Rahul. So Rahul, as we all heard, is at the Washington AG's office. And Rahul, talk to us a little bit about the enforcer's perspective. Your office has brought some cases. You, I think, and a select number of others have been viewed at the forefront of enforcement in this space. What are your thoughts about all this? Where do you think enforcement is going? Thoughts about where enforcement has been, decisions that have been made so far, et cetera.
Thank you, Adam. So obviously, before I start, standard enforcer disclaimer, I'd like to mention that the remarks I make are, here on my own, and they do not necessarily reflect the views of the Attorney General for the state of Washington or the Attorney General's office. So, taking it a little bit of a step back, I think the activity that has brought, the most, that has, shined a light on our office in the labor competition front is our office's efforts to eliminate on a nationwide basis franchise no-poach provisions. These no-poach provisions, these franchise no-poach provisions, they're covenants in very lengthy franchise agreements. And these are agreements between a franchisor and a legally distinct and independent franchisee that restricts employee mobility among the locations within the franchise system. We launched this investigation in January 2018. And in that time, we have investigated somewhere around 400 to 500 companies. Our criteria was any franchisor that has a meaningful presence in the state of Washington. Through that investigation, we've identified about 225 franchise systems that used a no-poach provision, either currently or at some point in recent history. And to resolve our investigation, we entered into binding agreements with those systems to eliminate their use and enforcement of no-poach provisions nationwide. Now, much like the tech cases from a decade ago that you mentioned early in the podcast, Adam, Our office views these no-poach provisions, these franchise no-poach provisions, as per se violations. And in fact, one of the companies that we investigated declined our initial offer to resolve the investigation, and it forced us to file suit. And in our motions to dismiss briefing, which we won, we laid out, why we think these are per se violations. And I think, I would say that's probably one of the bigger questions that people have, especially in the franchise context, is why do we think these are per se violations? And at least from my perspective, the reason is quite simple. To begin, I think we can all agree that application of antitrust law is not limited to conspiracies among sellers. It applies as equally to conspiracies and coordination among buyers, including buyers of labor. Labor markets are input markets, and there's really no basis to treat labor services different from any other type of production input. So from the antitrust perspective, firms that compete to hire or retain employees are horizontal competitors in a labor market. And this is true, regardless of whether they compete in any outbound product market or service. So while the categories of per se violations are somewhat limited, chief among them are agreements among horizontal competitors to divide markets or fix prices. And that's what these franchise no-poach provisions are. With respect to market allocation, market allocation occurs when competitors at the same level agree to divide up the market for a given product or service. So here we have separate individual units within the franchise system. They're all competing as employers for the same workers. By agreeing not to hire, solicit, or recruit the other's employees, the franchise units are basically allocating employees between themselves based on the employee's current employer. That is a market allocation. Similarly, price fixing, right? That's also a very traditional per se violation. Now, price fixing, because I assume it has the word price in it, it's often thought of in terms of product markets. But if we were to reorient ourselves and use labor input market language, price fixing is wage fixing. And, with price fixing or wage fixing, whatever adjective you're using, it doesn't matter whether that the price or wage was literally fixed or agreed to, but rather simply suppressed. And here, that's what the franchise no-poach provisions, that's what they do. Franchise systems all have their specific quirks, and a franchise unit who has a need for a worker would see value in an employee already being familiar with that system's quirks, and they may pay a premium for that worker. So by eliminating what would otherwise be a competitive market for these qualified and trained workers, no-poach provisions would almost certainly have the effect of keeping employees' wages or benefits suppressed. So that's, kind of a long-winded way to say that we view these provisions as, it's a new market. They're a labor market. That's a newer space, but they resemble very traditional market allocation price fixing agreements. And at least from my perspective, I think, the way I say it that way, I know it sounds relatively straightforward, but if it were that straightforward, I don't think we would be having this conversation. So what are the points of confusion that I think that present itself with franchise no-poach provisions specifically? And I think, there are three. One is that there's a co-branding issue. The second is that these no-poach provisions are baked into a broader legitimate franchise agreement. And then three, there is, there's a seemingly vertical relationship between the franchisor and the franchisee. With respect to the co-branding, right? With the tech cases, it's a lot easier to recognize that eBay and Intuit are separate entities. That's easier to conceptualize than recognizing that McDonald's franchise 1 is a separate entity from McDonald's franchise 2. That's just a naming or a branding convention, right? The reality is that, at least in the franchise context, the units within a franchise system continue to be separate entities. That's a big part of the bargain and benefit of franchising, that the small business owner franchisee gets to be an independently owned and operated company, and the franchisor gets to expand its footprint while minimizing certain costs and liabilities. And this is the independence and autonomy. It's especially true when it comes to employment decisions. While there is some necessary coordination when it comes to their output products, the fact that all McDonald's burgers have to look and taste the same, That's not the case when it comes to hiring or employment decisions. Franchisors historically have disclaimed any authority or ability to dictate franchise-level employment decisions, and often state as much in the franchise agreements themselves, and that makes sense, right? We can all imagine the joint employer exposure issues that would present itself if a franchisor exercised control over a franchisee's hiring decision. So I think that kind of eliminates a little bit of the co-branding issue. I mean, what we ultimately have are we have separate entities, using Justice Stevens's language in American Needle. We have independent centers of decision-making here, employment decision-making, who would otherwise compete with each other in a labor market, but do not because they agreed not to. Now, the other point of confusion is the fact that these no-poach provisions are a single clause baked into a broader, otherwise lawful and legitimate franchise agreement. And this is something where the Department of Justice and my office disagree. Department of Justice finds this relationship to be somewhat compelling and has argued that franchise no-poach provisions should be subject to the ancillary restraint doctrine. Our office finds this position to be somewhat misguided. The ancillary restraint doctrine, very simply states that an agreement that would otherwise be per se illegal escapes per se liability if that restraint holds the promise of pro-competitive benefits, and two, is necessary to effect the broader legitimate agreement. The franchise no-poach provisions fail both elements, and therefore the doctrine is never triggered. So starting with the second element, whether the no-poach provision is necessary, the facts of our investigation just belie that argument, right? As initial matter, 60 to 65% of franchise systems use a no-poach provision. That means 40 to 35% do not. And the lack of a no-poach provision with those systems have not hindered their growth or success. More of the 60 to 65% of franchise systems that did use a no-poach provision, a large percent, if not a sizable majority, as I mentioned, over 225, entered into agreements with my office to immediately eliminate use of those provisions nationwide. And a lot of them stopped using the provisions prior to our office's investigation. So considering that 40% never used it and the remaining 60% stopped using it immediately, and the fact that we've seen no mass failure or collapse of franchise systems, it's hard to credibly say that this provision is necessary to the main transaction. As to the first element with respect to pro-competitive benefits, to satisfy this requirement, there needs to be some organic, plausible connection between the restraint and the main transaction. And I'm not aware of any franchise that has articulated or argued a pro-competitive benefit to these provisions. At the least, I think it's fair to say that the mere fact that the restraint is baked into a broader legitimate agreement does not by itself shield it from antitrust scrutiny. Otherwise, you would be able to shield any number of anti-competitive conduct by simply including it in a broader legitimate agreement. So here, when we're dealing with a multi-hundred-page franchise agreement that is mostly concerned with the economic relationship between the franchisor and the franchisee, how fees are calculated, as well as homogeneity of the franchise system's output markets and end customers, the fact that all burgers have to look and taste the same, it's not clear how a single labor market allocation agreement is organically or plausibly connected to the main transaction. And finally, to the third point of confusion here is this somewhat seemingly vertical relationship between the franchisor and the franchisee. And I think to a large extent, they obviously do have a vertical relationship, at least with respect to their product market, but not with respect to every aspect of their relationship is a vertical. So there are different types of franchise systems out there. There are franchisors that have company-owned stores that look and feel just like a franchise store. In that situation, I think it's pretty clear that the franchisor and franchisee are direct horizontal competitors in the labor market. Both the fact that the franchise and the company-owned store a few blocks down, the fact that they may want to hire the same cashier or the same line cook or the same store manager, that means they're competing for the same employee and or would be competing were it not for a no-poach agreement. And even when the franchisor does not have any company-owned stores, where it's just kind of a corporate headquarters, there are still certain flavors of no-poach provisions that restrict the franchisee from hiring or recruiting an employee of the franchisor. And here's something that's important to remember, that you can be a horizontal competitor in one market, here a labor market, even if you're selling different products or services in your outbound market. So the fact that the franchisor is in the business of selling franchises and the franchisee is in the business of selling burgers, that doesn't matter. If the two companies want to hire the same person, they are by definition direct horizontal competitors in a labor market. And now there's the third scenario, and this is where the franchisor has no company-owned stores, and the no-poach provision at issue only restricts the franchisee's ability to hire or recruit an employee of another franchisee. Here, it's important to remember that in this scenario, franchise agreements are uniform. Every franchisee knows that the franchise agreement they are signing is identical to one another franchisee signs. That knowledge includes knowing that as much as they are restricted from poaching another franchisee's employees, that other franchisee is equally restricted from poaching their employee. So here the franchisor is acting as an intermediary, coordinating activity between different franchises. This is a hub and spoke conspiracy where the franchisor is the hub and the franchisees are the spokes. It also, I think it's important to remember that the orientation of the parties is not necessarily determinative to the mode of analysis. So formalistic vertical restraints that have no cognizable efficiencies can have horizontal anti-competitive effects that are per se illegal. The reason we typically view intra-brand restraints under rule of reason is because they may generate efficiencies that promote inter-brand competition. But that restraint and that supposed efficiency have to be in the same market. Here, the no-poach provisions' direct effects are on competition, or the direct effects on competition occur in inbound labor markets, not outbound product markets. So even if one could argue that the no-poach provision helps McDonald's compete with Burger King in selling burgers, that's an out-of-market benefit that does not excuse anti-competitive conduct in the labor market. And it's not at all clear, at least to us, how an intra-brand restraint in the labor market would promote inter-brand competition for workers. So that all is basically like my longer-winded way to say that these are the reasons we believe per se liability applies to franchise no-poach provisions, because at their core, they're no different than any other type of market allocation or price fixing agreement. It's the nature of the restraint and not the particular market or industry that is critical to the per se rule applying. So applying per se liability to franchise no-poach provisions is not expanding the per se doctrine. It's not creating a new category of conduct subject to liability. It's simply applying our pre-existing per se jurisprudence to a traditionally under-enforced industry and market, namely the franchise industry and the labor market. With respect to kind of going forward, my office, like I said, we've been doing this investigation for a little over 2 years at this point. We have at this point, like I said, we have entered into binding agreements with 225 franchise systems. I think it's fair to say that that represents the near entirety of franchise systems in the state of Washington that have any meaningful presence. At this point, we are not necessarily actively investigating any new franchise systems, but to the extent that something comes across our desk, we would obviously pursue and take any appropriate enforcement action against it. And I think that's kind of an overview of our office's efforts in the franchise no-poach space.
Oh, that's really great and very informative. Let me just ask one question. I think a lot of practitioners, when they find that there is a meaningful distinction in enforcement policy or view of the law between the federal and the state levels, or for those dealing internationally between different jurisdictions, they get a bit concerned, and the problem then becomes, how do you best advise clients. In that context, you mentioned that the DOJ has appeared to be a little bit more sympathetic to the arguments of franchisors, and perhaps thus viewing it as viewing the franchisor or franchisee agreements not as per se, but as rule of reason. Do you attribute that to a difference in a view of the facts, or is it a policy consideration underlying the DOJ's view that you think is distinctive vis-a-vis Washington State?
That's a really good question, and I think as a preface to the answer, right? I think us all being antitrust lawyers, us all being competition practitioners, and seeing the value in competition in markets, normal product markets, I think competition among enforcers is not necessarily a bad thing. So having enforcers necessarily, disagree on application or construction of law may create microcosmic points of frustration in the moment, but I think is actually healthy. It allows the theories to be stress tested. It's better than uniform belief in a bad construction of law. So with respect to why DOJ and the state of Washington may have a difference of opinion, I can't really tell you what's going on in DOJ's mind. I have the utmost respect for DOJ's antitrust division. The career attorneys there are some of the best in the country. But I think it would be a little silly for us to ignore the fact that DOJ and the FTC issued guidance to HR professionals towards the tail end of 2016. And at least from the black letter of reading that guidance, it seemed pretty clear in terms of in terms of how strictly it applied. And one of the things that has changed since then is obviously a change in administration. Now, it is perfectly appropriate and fine for new administrations to have different programmatic policies and priorities, as well as even having different constructions of law. And I know I can't really tell you how much that goes into it, but I think, like I said, I think it would be silly to completely ignore that fact. I think another point that may raise some of the disagreement, at least between DOJ and our office, is, to be fair, I think we've looked at it a little bit more than Department of Justice, right? There were a series of private class actions filed out here in the Eastern District of Washington, where Department of Justice filed statements of interest articulating their position that the franchise no-poach provisions should be subject to the rule of reason. Our office filed the amicus briefing, also in those cases taking the opposite position. One of the arguments DOJ made was the question of ancillarity, that these were ancillary restraints. And I think the broader macro level facts at the time were a little bit, I don't know if they're more embryonic or more vague. They just weren't necessarily as clear as what my office was able to see in real time with respect to the fact that we had a better sense of the pulse of how many systems used these provisions, how many didn't, how quickly the systems that had the provisions were willing to cut them or get rid of them. So I think we had a slightly better understanding of the actual value of these provisions to the systems themselves. I mean, ultimately, I think for most franchisors and franchise systems, they will at this point agree that these are high risk, low value provisions. So I think that really changes the analysis of whether they're ancillary or not.
Okay, that's very helpful. Thank you. Well, listen, we've been going a while. We've heard a lot of interesting stuff from all of you. I think now might be the time to wrap it up. First of all, I'd like to thank every one of you for taking the time to prepare for today's program and to participate and share your very thoughtful views.
Be safe.
A quick
and well,
shout out to my
and
colleague, Harlan Rosenson,
John, back
Weil,
to you.
who helped put this all together and organized everything. I just want to thank him for all his kind efforts. So with that, I think I'm going to turn it back over to John Roberti.
All right, thanks, Adam. Leslie, let's go to you. What are some of your takeaways from today's panel?
So that was a great panel. I think there's a lot to take away. I think the biggest thing that I took away from it is, as Beatrice pointed out at the beginning, there is a lot of uncertainty here. And the standard antitrust playbook may or may not work for labor markets. As many of the panelists pointed out, the questions that we ask and the traditional analysis that we use as lawyers and economists don't necessarily translate in the labor market space. As Dean said, a job is not a bar of soap, and we need to take that into account. I think, that those differences may present some unique and interesting challenges in these cases as we move forward, but there's a lot of uncertainty about ultimately whether some of these differences will matter and how courts and enforcers approach them. And some of these uncertainties go to the very core of an antitrust case, as our panelists talked about. Should conduct be per se unlawful, or should we apply the rule of reason? What is the affected commerce in a no-poach case, and particularly a criminal case with respect to the sentencing guidelines, and how should we calculate that? So we're going to have to stay tuned to these cases to see where this goes.
Leslie, one of the items that I thought was most interesting was in the last few minutes of the panel, we heard from the lawyer from Washington State Attorney General, Rahul, that sort of how that office was looking at these cases. And I think it was a nice and very transparent explanation of how Washington State is approaching it, because Washington has taken a different approach than a number of the AGs and the DOJ as well.
That's right. And I think that leads to one of my other takeaways, which is, we need to think carefully about, jurisdiction and where our clients are operating. As you pointed out, we know exactly where the Washington AG's office stands, as we just heard, but that's different from the DOJ position. And they don't agree. And so when we are thinking about litigation, thinking about counseling clients, we need to take into account where they are operating and where they might be subject to an enforcement action. The same is true on an international scale. As we heard, there are a lot of jurisdictions around the globe that have been looking at no-poach, and it's increasingly becoming an important part of the antitrust landscape. So for multinational companies, we also need to take note of that and ensure that we're thinking about what the developments in no-poach are in all of the countries in which our clients operate.
Leslie, thank you. And thank you, Beatrice, as well, for your really helpful analysis of this panel. I also want to thank Adam for organizing the panel and for all the panelists who did such great preparation to get ready. And most importantly, I want to thank folks who are listening to us, our members. We're very grateful that you're giving us a chance with this virtual spring meeting approach. So until we speak again, thanks for listening. Be well, be safe.
Thank you for listening to this Virtual Spring Meeting 2020 edition of Our Curious Amalgam. It is produced and shared around the globe by the American Bar Association Antitrust Law Section. The opinions expressed by the participants in the podcast are their own and do not necessarily represent those of their employer or other organization. If you like what you heard or would like to become a member of the American Bar Association, please check out what the Antitrust section has to offer at ambar.org/antitrust. If you have suggestions for topics or are interested in participating in a future episode, please reach out at podcast@ourcuriousamalgam.com. Until next time, thank you for listening.